We will go on the record in the matter 25 CM 116, State of Wisconsin versus Jeffrey Holland. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person. Mr. Holland also appears in person. We're set today for a plea and sentencing. Is this matter proceeding as such?
Unfortunately, Your Honor, we are requesting at this time to adjourn and reschedule. The reason being Mr. Holland has completed all but, was it 1 or 2 classes?
2 out of 4.
Has completed all but 2 classes of Mr. Dave Hatch's class. It sounds like he was scheduled for the 3rd. There was some sort.
Welcome back to Behind the Gavel, and this courtroom calendar is already moving fast. We've got defendants asking for more time, classes not completed, fines they can barely afford, and judges trying to balance compassion with accountability. But don't get comfortable, because what starts as scheduling problems turns into serious felony sentencing, cash bonds, restitution, and one OWI case that will leave everyone talking. Subscribe now, because this one builds all the way to a massive final ruling.
If I'm recalling correctly from when he spoke to me, some sort of issue that came up, he needed to reschedule and just wasn't able to get that class completed, but he's on track and is expected to finish that shortly.
(10:45) on May 11th.
Unfortunately, I have a sentencing at that time in Sawyer, Your Honor.
3 o'clock on May 11th.
Unfortunately, I have a preliminary hearing right after then in Sawyer County.
When's your next meeting with Mr. Hatch?
I have to touch bases with them in the basement when I leave here, Your Honor. But typically we were meeting at noon every Monday.
So would you typically probably be meeting him this Monday the 20th and then Monday the 27th?
Yep, I'm going to go touch bases with them and see if I can pound those out Monday. Yep.
Hopefully you can. April 28th.
That will work.
11?
That will work.
April 28th at 11.
Yeah, Your Honor, I was under the impression when I started these classes that there was going to be 2 of them, and
4, I think.
there is 4. So I apologize for.
That's okay. Yeah, thinking and doing, and hopefully you can just do the 20th and the 27th, because then otherwise, honestly, I wouldn't be able to get you scheduled in here until June, 2nd week of June.
Provided there's no hiccups with Mr. Hatchett, I mean, but.
Yeah, it sounds like you'll be able to get them done.
Yeah, I don't see any reason why we shouldn't be able to do that.
Okay. And I believe it would be then a plea to the disorderly without the modifier for costs.
That is correct, Your Honor.
Would you be able to come up with the court costs of $443 all at once?
Oh, we're really broke right now, Your Honor.
That's fine.
I actually missed last Monday's class because we didn't even have fuel to get there. So
okay. You're in Grantsburg, so I'm going to tell you it's pretty easy for me to get you with a warrant if I need to.
Oh, yeah, you guys know where to find me. I'm at home with my handicapped girlfriend.
Can you put anything down in 2 weeks?
Yes, I can. Absolutely. Let's shoot for like half of it.
Oh, that's okay. That's great.
Okay.
You can do half. Right. I'm going to be more than happy with that.
Okay.
So, okay. All right. We'll see you then.
All right. Thank you, Your Honor. So it's the 28th.
We will go on the record in the matter 25 CM 202, State of Wisconsin versus, 26 CM 30, State of Wisconsin versus Jason Friel. The state appears through Assistant District Attorney Jose Vila in person. We have Amber Sherwood, Defense Counsel, in person, as is Mr. Friel. We're set here today in this matter for a status conference. Ms. Sherwood, please update the court.
Yes, Your Honor. We're asking for a plea and sentence date as early as the court can allow. We have an offer to prepay half the restitution. I have talked with Pastor Jack. They will be paying the full restitution today.
How much is the restitution?
$950.
That's the total amount that's due?
Yes, Your
That would
Honor.
be agreed upon? Okay. And what would the agreement consist of?
The agreement would consist of paying the restitution, and I believe this was to go down to a citation.
And I would need $114.50 to be prepaid. And I'm giving you a deal. That's the lowest I can go. So when do you think you can have that paid?
Your Honor, he says he's gonna pay the full $950 by today.
The 115.14.
Oh, the $115.
$114.50, I guess. That's what it would be. When could you have $114.50?
Pastor Jack has informed me today he could have.
Oh, excellent. Well, Pastor Jack, your pastor, and you swear that that full amount, the $950 and the $114.50 will be paid today? Are we in victims' rights compliance to be able to proceed then?
Yes, Your Honor.
Formal motion to amend,
So made.
granted. How does he wish to plead?
Guilty, Your Honor.
All right, the court will enter a guilty plea. I will order $950 in restitution to be paid today, $114.50 in court costs to be paid today. Are we removing the domestic abuse enhanced modifier?
Yes, Your Honor. This will just be for a simple ordinance. Yes.
All right, so just for the disorderly conduct ordinance, no modifier. A guilty, no contest plea is entered on your behalf, and I'm ordering that to be paid. If you fail to pay, a warrant will be issued. Okay, so I have the pastor here. We're all good to go. I trust we're good to go. So you're good to go. So just go make sure that both of those amounts get paid, and we're good. So pay the clerk all of it. Okay.
Thank you, Your Honor.
Thank you.
Now this is a key courtroom moment. The court is basically saying, if the restitution and court costs are paid today, the case can resolve much more lightly than it otherwise might have. That's why the pastor's role matters here. He is not just moral support, he is helping make the financial part happen. But here's the question, should someone's ability to pay quickly make this big of a difference in how a case ends?
I just want to what?
It's all done.
It's all done? You actually don't even, you don't have to come back. You're done. Handled.
Doesn't matter.
Have a good day. You let me know if you need anything.
God bless you. Judge, God bless you.
God bless you. 25 CF 80, State of Wisconsin versus Shane Cook. The state appears through Assistant District Attorney Jose Vila in person. Mr. Cook appears in person with counsel Nicholas White. We're set today in this matter for a plea and sentencing. Mr. White, can you please recite the agreement on the record?
Your Honor, because Mr. Cook wasn't able to get the AODA done just yet,
Okay.
we're asking for more time. We were optimistic we'd have it done today. Just looking at my notes from when I called him about 2 weeks ago, but then I found out yesterday that the AODA is set for this Monday, so the timing just didn't work out to have it done today.
And that's A-okay. I'm fine with that. It's kind of a bummer, not that Mr. White doesn't mind, but he had to drive all the way here.
I know.
So I don't know when he found out, but if you would have let him know a little earlier, he wouldn't have needed to.
I just got my phone turned back on yesterday as well.
Yes, but not that he gets paid either way, but it could have saved extra office time probably. So
Yeah,
let's set another date and time. Mr. White, do you know when you're going to be here in person another time without me looking?
I don't off the top of my head.
And see, I can try and do that. Because I know your status blocks, but I that again what I did yesterday when I'm trying to search. Okay. Nope. Well, I have a question. Well, we're gonna move that and have the status. Never mind. I don't see that you're coming here for anything.
I don't think so, Your Honor. I think it's gonna be a
Schedule
while.
something else. So how long do you think it's gonna take you?
I have the thing right here.
And does he have to complete all the recommendations and follow through?
Your Honor, it was, I was gonna leave that up to the prosecutor for today, just to see, when
Prosecutor.
should we be coming back?
As I read it, the offer is get the AODA prior to the plea.
Okay.
I could do. February 18th at 9.
9 o'clock in the morning.
That works for me.
That works for me.
All right,
Open
February
that day.
18th at 9 a.m. We will see you then, and just block it for the whole half hour. All right.
All right.
Then we're adjourned. Thank you.
Yes.
Okay.
We will go on the record in the matter 24 CT 101, State of Wisconsin versus Jacob Lubick. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lubick appears in person without counsel. We're set for a status. Where are you?
I have the Intoxilock installation scheduled for next week, Wednesday. And then all I have to do after that is schedule my test and then take the test, pass the test, and I'm done.
And it's the driver test?
Well, it's a little weird. It's a driving test, a science test, and then a road skills test.
A science test?
Science?
Oh, a science. I'm like,
Yeah.
a science test to drive now, huh? Oh, a
Yeah.
science
Yeah.
test. Okay. All right. Okay, that makes sense. So you have to do the written stuff and all of that stuff.
hmm
Okay, and so when do you think you're gonna be able to do those things?
As soon as they let me.
Okay, because I'm telling you, this is getting extremely old. It's
hmm
500 days old almost. April 28th at 9:45, April 28th at 9:45. Okay, hopefully
Okay.
you have it all by then. If you have it all done by then, you have your license, go to the state, show them the license, you won't need to come back. Otherwise, you do need to come back and continue to update me as to why and when and what. Thank you. Mr. Wellman. We will go on the record in the matter 24 CT 66, 25 CT 27, State of Wisconsin versus Andrew Wellman. The state appears through Assistant District Attorney Kevin Schmidt, Jose Vila in person. Mr. Wellman appears in person without counsel. We're set for a status conference. Mr. Wellman,
Your
not
Honor,
yet.
I got nothing done. I've been broke as a joke. Stuck in the paradox of it takes driving to get employment and it takes money to get that. I'm on EBT and when I leave here, I'm gonna go put my last $20.
Well, the offer is
and
paid to the charge for costs. Dismiss the other one. It's 600 days old.
I understand.
So I can't give you more time. I just gave him only 2 more weeks because it's 500 days old. And then the next time it's going to be, I'm sorry, you're out of time. You pretty much reached that now. So
I think I understand. This is going on like 2 years, right?
600 days is a lot of days.
Yeah, that's like 2 years.
610 days to be exact.
Right.
So that's the offer. Plead to a charge for cost, dismiss and read in the other, get your license or dismiss. And so I don't know how much you need to raise to be able to do this, but is there an amount that you know that you have to have? Or it's the ignition interlock device and getting the car to put it on and all of those things?
Good news, the place in town, what's it called, Aurora, sent me a letter that even though I let the time lapse before going to do these
Sessions.
sessions, that if I contact them, I think it's something like Like I pay them like $150 and I have I'm assuming a very nice conversation with them that they will waive the necessity to have another alcohol assessment. So that's a good deal.
You'd be the
As
first I've
for-
heard that it would
As for
exist.
the rest of it, well, like I assumed I was just gonna have to have another assessment done with the $300 some, and
That's
then
usually-
you're waiting longer time too. So I think that would be really decent of them. As for the rest of it, I go, it's more money than I have. Obviously, having a bunch of
You have to
fines
get a
stacked on
car?
top of it is going to be worse.
You have to get a car.
I have a car.
Okay, so you finally have the car and you've already have it paid and it's registered in your name.
Yeah,
And do you have an ignition interlock device
I
placed?
don't. And I have,
SR22 insurance?
I don't. I have to have the insurance before the interlock.
I can give you until April 28th at 9:45.
Okay. That's what, not even 14
weeks.
days. It's like 10 days, isn't it?
Yep. That's what I
Okay.
just gave that other gentleman. Because it's 610 days, 610 days old.
Right.
You can't keep pushing this out, so it'll be 3 years then, and then 4 years, and I can't keep pushing them out as much as I want to, and I want you to get your driver's license, that's the number one. We're going on 2 years,
Right. I understand that.
so see what you can do by the 28th, and I guess I'll see if I'll give you one more time, but I can't keep pushing these out because it has a trickling effect. It doesn't just affect you, it affects a whole lot of things. Data, caseload across the whole state of Wisconsin. They look at all of these things. How long does it take you to do your cases? Are you a slow judge? Do you not know how to run your courtroom? Do you not know how to do those things? Do we need more judges? Do we not need more judges? Do we need different judges? Do we, all of those kinds of things. So generally cases like this are supposed to be done in 6 months.
Right. I can understand that.
So April 28th, 9:45, see what you can do. Come on back and we'll go from there.
Thank you.
Thank you. Does Miss Mose have her license?
I can check quickly, Your Honor.
Mr. Buskirk? We will go on the record in the matters 25 CM 228, 25 CT 47, State of Wisconsin versus Scott Buskirk. The state appears through Assistant District Attorney Jose Vila in person. Mr. Buskirk appears in person without counsel. We're set for a status conference. Mr. Buskirk, have you gotten your license yet?
No, I haven't. I can't afford the assessment class right now because I lost my job. So I can't drive.
Okay.
But I
so
get a job right across the street pretty soon. So
you can pretty soon.
yeah, I just gotta wait for them to call me so I don't have to drive so far. It's way easier.
And the offer is, I believe the offer was plead to the misdemeanor bail, jump for costs
Okay.
and get your license.
The update was if he gets his license, we'll dismiss everything.
Yeah.
That was the last updated offer.
So this one is not, your cases are not that old.
Okay.
So I'm willing to give you time to do that. They're
Thank
only
you.
147 days,
Okay.
give or take.
Okay. Yeah, I went to go do that and I couldn't come up with the money for the class to get my license, but I'm trying.
So can you get that done?
Yeah. I should be getting another bonus here pretty soon, and I think I can use that money to get it.
June 8th at 11:30. June 8th at 11:30. What I want to see is that you've already paid for and taken the class by
Okay.
the time you come back.
Okay.
Then you can update me on the other steps that you need to take.
Okay. Perfect.
So June 8th, you can come up here and get your notice.
Okay. Thank you.
And then you can go. Thank you. We will go on the record in the matter 25 CF 156, State of Wisconsin versus Markeith Philippi. The state appears through Assistant District Attorney Jose Vila in person. Mr. Philippi appears by video conferencing in custody in Burnett County Jail. We have his attorney, Emma Hanu, in person. We're set today in this matter for a motion to modify bond. Ms. Hanu.
Thank you, Your Honor. We were requesting to convert the existing cash bond into a signature bond for the reason that Mr. Philippi in this case was given a deferred judgment of conviction. He is still beholden to the conditions of bond under that, as he's been incarcerated, sitting a sentencing after revocation sentence. He's obviously been unemployed and does not have the income to post that amount of bond. Allowing him to get a signature bond would allow him to be released, I believe it is next week, with the additional good time he was granted.
Why wasn't this changed on the 29th?
I think we just all overlooked it, Your Honor.
It should have been a signature bond back from January 29th when we had the plea and sentencing.
Yeah, I think part of it, I think we overlooked it because he was going to be sitting until May.
Yeah, so he really, how long, when does he sit until?
I believe it is next Wednesday. It would have.
Well,
yeah.
Here's the deal. The court is retroactively saying it's a signature bond back to January 29th, 2026, because that's when he entered into his deferred agreement. He doesn't get double time for sitting this when he's sitting another sentence. It should have been modified and changed. He should not be sitting on a cash bond for deferred judgment of conviction he's already pled to.
That works for us, Your Honor.
All right. And we're good to go.
Perfect.
Because we have nothing else to do in that case, right? We've already done the plea. We've already entered the deferred 1 year. We're good to go. All right.
This bond issue is important. The judge is pointing out that once a deferred judgment agreement was entered, keeping him on a cash bond did not make sense in this situation. A signature bond means he does not have to post money, but he is still legally bound to follow court conditions. That correction matters, because even small paperwork oversights can affect whether someone stays locked up or gets released. What do you think was the court right to fix this retroactively?
But he still has to pay $150 within 60 days of being released to the district attorney's office.
Yes.
Don't forget that, Mr. Markeith, or Mr. Philippi.
Yeah,
Okay?
I also the $60 to the letter. Or $50, I think it was.
Your Honor, you added a condition of writing an apology letter to the
That's
officer.
right. Yes.
It was originally, the letter is complete. It's just he doesn't have the money. It's the same timeline as the administrative fee.
Yeah, the $50 within, by 60 days of release. Yep. Thanks, Mr. Philippi.
Yep.
Thank you. We're
And
adjourned.
I will be
Go
released.
ahead.
I will be released on the 20th instead of the 3rd because I got put in a worker.
Yeah, the good time, the extra time. All right, good. I'm glad to hear. Thank you, Mr. Philippi.
Thank you.
Your Honor, Miss.
Yes, I can. Can you hear me?
Yes, I can. We will go on the record in the matter 25 CM 243, State of Wisconsin versus Emmerich Barrett. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Barrett appearing in person. We do not have Thomas Mulligan. I do not have him opted into the case. Is he still your attorney, Mr. Barrett?
I believe so.
He is not opted into the case. So as far as the court is concerned, he is not your attorney. So I don't know. I don't know what's going on.
I haven't heard anything.
Mr. Vila, is there an offer that was presented?
There was. It was to complete the domestic violence education course with Mr. Dave Hatch. At which point, after successful completion of that course, we would enter into a DJOC for 6 months. Successful completion, this case would be dismissed. I was speaking with Attorney Mulligan on this one, so I don't know what's going on the back end here, if anything else was conveyed differently to his client.
All right, that's the offer. Do you understand that offer?
Yes.
And have you been doing that class?
Yes, I have been in contact with David Hatch. I've went the past 2 Tuesdays.
Excellent. What I'm going to do is I need you to talk to Mr. Mulligan to see if he is going to represent you, or if he's decided that this is something that you can represent yourself, maybe to save money or to do something. I don't know. All I know is I do not have any notice that he is actually your attorney. And I would need that, the retainer, the notice of retainer in the document for the court to acknowledge that. But I can look to see if we have him coming up in any other hearing, and I can try and set it for that date and time. Otherwise, I'm just going to have to set it, and you're going to have to talk to him to see if he is still like representing you. Okay. Mr.
Just for the court's record, it does look like we've had 2 previous hearings in this case, and Mr. Mulligan was present for both of them.
Yep, and I understand that all well and good.
That's all I wanted
Each
to
time
say.
I said he doesn't have a notice of retainer yet, but I'll just be like, but he needs to get that in. Otherwise,
Nope,
not-
I understand, Your Honor. I just wanted to clarify.
I have him coming back on April 24th. Is that right? Wait, that's Thomas Mulligan the second. Let me just quick see my calendar. It says an all day. No, he is not. He's in front of Judge Winton, so that's not my matter. May 11th at 3. Oh, at 2:30. All right, I have him coming back May 11th at 2:30. So we'll schedule your next hearing for May 11th at 2:30. Continue to do what you're doing and just talk to Mr. Mulligan, because it may be a you and him thing where maybe he's not really representing you, or maybe he is. I don't know. You talk to him and you find out what's going on, but then let him know that I scheduled it for the May 11th at 2:30, okay?
Okay.
All right. Thank you.
Yep.
Word. Beechler. The state appears through Assistant District Attorney Jose Vila in person. Mr. Beechler appears in person with counsel Joel Feliski. We're set today in this matter for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I've received discovery from the state. It is quite voluminous. It consists of 36 gigabytes of data. I have not had an opportunity to fully review all of that. In addition, there are certain documents within that discovery that the defense has stipulated cannot be provided as copies due to sensitive information to Mr. Beechler. My point being, Your Honor, I'm just asking for a status conference to review that discovery in full and discuss with my client. I will also let the court know that I received an email from the state this morning. They don't yet have an offer on this case. They are waiting for further input from the victim.
Okay, and this is a Mr. Schmidt case?
That is correct, Your Honor.
Okay. Is Mr. Beechler contemplating, or as part of the agreement, can somebody tell me the IDIP program?
I think that certainly could be an option, Your Honor. Again, the state hasn't given me an offer yet.
Because if that's the case, you're gonna have to pry him on that and say, okay, I understand no offer, but the IDIP program, to see if that would come into play at all, because that's going to take 4 months to complete.
Certainly, Your Honor.
And this is already from November. So I'm going to have a shorter turnaround with regards to status. Can you do February 20? Let's just say, can you do February 24th at 2?
Unfortunately, I have hearings in Sawyer County at that time, Your Honor.
February 27th at 10:30?
That will work, Your Honor.
All right, February 27th at 10:30. We will see you then. Just for Mr. Beechler and, okay. Come and get an IDIP program, then you can look at it, because that could go a long way. I mean, it did in my last case, was for an OWI second injury. I don't know. Talk to Mr. Schmidt. We will go on the record in the matter 25 CF 125, State of Wisconsin versus Charles Kurkowski. You're free to go.
Okay. Thank you.
The state appears through Jose Vila, Assistant District Attorney. We have Joel Feliski, Defense Counsel in person. Mr. Kurkowski appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I believe the parties have reached an agreement to resolve this matter. The agreement would involve Mr. Kurkowski pleading to the count of burglary and the complaints with the habitual criminality repeat or dropped. There would be a agreement between the parties for an argued sentence. The state would be capped at 3 years, recommending initial confinement. That is my understanding of the agreement. I believe we just need a plea and sentencing set.
And this is a Mr. Schmidt case.
That is correct, Your Honor.
And so no PSI, just,
No PSI, Your Honor.
and you said 3 state is capped. Is it 3 years initial, or is
3 years initial confinement, Your Honor.
what they're capped at?
Yes, Your Honor.
Okay. Okay, are we gonna have victims that make statements?
There's a chance.
There's a chance. And do you have an idea of how many potentially?
2 would be at the most.
I could do February 24th at 11.
That will work for my calendar, Your Honor.
February 24th at 11, block a whole hour. All right, thank you. We are adjourned. We will go on the record. Do you need time? For 25 CF 138, State of Wisconsin versus Jennifer Rawls. The state appears through Assistant District Attorney Jose Vila in person. Ms. Rawls appears by video conferencing. We have her counsel, Joel Feliski, in person. We're set for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I believe the parties have reached an agreement in this matter to resolve. The agreement would be for Ms. Rawls. I apologize, I'm just pulling up the original offer now. My apologies, there we are. The agreement would be for Ms. Rawls to enter a plea to misdemeanor theft in the 25 CF 138 file. The felony bail jumping count would be dismissed and read in. Stipulation to the restitution of $46.36. A joint agreement between the parties for 10 days jail. I believe that all we need to do is set schedule for a plea and sentencing. Your Honor, I would request that this would be set out some ways to allow Ms. Rawls time to gather the funds needed for the ankle monitor program.
And that's not a given, you know. It's an argument you need.
Yes, Your Honor.
Especially with the crime of this nature and not the OWIs. All right. I could do March 9th at 1:30.
Unfortunately, I have a preliminary hearing at that time in Sawyer County, Your Honor.
March 13th at 10:30.
That will work, Your Honor.
All right, March 13th at 10:30. We will see you then in person. We are adjourned.
Thank you.
Now all we have is Mr. No? Oh, son of a nutcracker. Gotta dial into Mr. Hess.
Your Honor, I did review the plea with Mr. Hess over the phone. He was in custody. I have the
Just
full.
wait, this is it's hard to dial in to the prison, and I might have missed them if I,
Oh,
so sorry, I have to quick do this.
Of
and
course,
then you
Your
can
Honor.
update me, sorry.
No.
I forgot that he was in prison. He changed the way we do it, so it makes it a little bit more difficult.
That's a shame.
It's the prisons, what can you do?
Your Honor, I was only going to say that I reviewed the agreement in full with him, but I wasn't able to get a signature.
Good, that's fine, thank you. I got it in one shot. There we go, there's Mr. Hess. Okay. All righty. And we have Mr. Quinn, that's at 2:15. Okay, so you have the plea questionnaire waiver of rights form?
Yes, Your Honor.
Please come forward.
Yes, Your Honor.
Thank you.
And Mr. Hess, can you hear me?
Yes.
Oh, to clarify, sir, an earlier question, the traffic tickets are going to be dismissed and read in.
Okay, thank you.
We will go on the record in the matters 25 CF 110, 25 TR 630 and 631, State of Wisconsin versus Daniel Hess. The state appears through Assistant District Attorney Kevin,
Just a logistic matter. I believe your microphone is off.
Thank you. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel in person. Mr. Hess appears by video conferencing in custody. I believe he's in Dodge Correctional Facility. We're set today in this matter for a plea and sentencing. Mr. Hess, you appear by video conferencing from Dodge. Do you understand that you do have a right to be here in person?
Yes, I do.
And are you asking the court to allow you to enter a plea and be sentenced by video conferencing?
Yes.
All right. Do you understand that at any time you have any questions or concerns and you need to speak with your attorney, I will send him into Zoom and give you a confidential breakout session, okay?
Okay, thank you.
If at any time you can't hear something or see something, please let me know so that I can make sure that you've heard and you understand everything, all right?
Yes.
All right, okay. So what is the agreement that's been reached, Mr. Feliski?
Thank you, Your Honor. The parties have reached an agreement here for Mr. Hess to plead to count one of the complaint. Count two, as I understand it, will be dismissed as a matter of law. A joint recommendation between the parties for statutory minimums on sentencing, which for an OWI of this category would be no less than 4 years of initial confinement.
All right. And that's the agreement that you have reached, Mr. Hess?
Yes.
Okay. All right. So, Mr. Hess, I have in front of me a plea questionnaire waiver of rights form. Did your attorney go over that document with you?
Yes, he did.
Did he essentially read it to you word for word?
Yes.
And did you understand everything completely?
Yes, Your Honor.
If you did not understand something, did you ask your attorney to explain it?
Yes, I did.
And he did so.
Yes.
You are pleading guilty to one count of operating a motor vehicle while under the influence, 10th and subsequent offense. Is that correct?
Yes, Your Honor.
And you did not sign this document because you are currently incarcerated and Mr. Feliski is here, and it's sometimes difficult with prison, mail, etc. But did you give him, or are you giving the court a statement on the record that if you had the ability to sign it, you would?
Yes.
You are pleading guilty again to the OWI 10th offense and, under the influence. You're 57 years old. You have 12 years of schooling. You can read, write. You understand the English language. Is that correct?
Yes, Your Honor.
Mr. Feliski, did you thoroughly go over this document with Mr. Hess?
I did, Your Honor.
Did you essentially read it word for word?
I did, Your Honor.
And at the time, do you believe he understood everything?
I did, Your Honor.
Did you fully explain to him what the state would need to prove guilt beyond a reasonable doubt for an OWI 10th and subsequent?
I did, Your Honor.
Did you go over with him the mandatory minimums as well as the maximum possible penalties he may face?
I did, Your Honor.
And Mr. Hess, you are not receiving any treatment for any mental health illnesses or disorders and no alcohol, drugs, or medications. Is that correct?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and Mr. Feliski went over those rights with you. I'm going to briefly go over them with you again. Do you understand that you would be giving up your right to a trial? You'd be giving up your right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You'd be giving up the right to testify on your own behalf or the right to remain silent and not have your silence used against you. You would also be giving up the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You would also be giving up the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you also understand that here the state would have to prove for count one, operating a motor vehicle while under the influence, 10th and subsequent offense on or around August 4th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a 10th countable offense. Do you understand what the state would have to prove?
Yes, Your Honor.
You understand this is a Class E felony, and upon conviction, you face a fine of not more than $50,000 or imprisonment of not more than 15 years or both, and that because of the nature and the gravity of this offense, and that you have nine or less countable or 9 countable offenses, and this would be 10th or subsequent offense, that the court shall impose a bifurcated sentence of a confinement portion of not less than 4 years of initial confinement. Do you understand that?
Yes, Your Honor.
Do you understand that there is an agreement here that's been reached in which the parties are going to recommend to the court the minimum confinement that is required and mandated?
Yes, Your Honor.
Do you understand that as judge, I'm not bound to follow that minimum mandatory requirement, and I could sentence you all the way up to the maximum if I thought it was appropriate? Do you understand that?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, I did.
In particular, there is a section called the probable cause section in which it basically says what happened and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant in this county and this state?
Yes, Your Honor.
Are you admitting here today that it is your 10th or subsequent countable offense?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Mr. Feliski, may the court use the probable cause section of the criminal complaint along with the statements made by Mr. Hess to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Hess, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes, he has.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes, he has.
Has he discussed with you the discovery and the evidence in this case?
Yes, Your Honor.
Has he discussed with you whether or not you have a defense or a lack of defense in this case?
Yes, he has.
Have you discussed with him any facts and any and all facts that you know to exist about this case?
Yes, Your Honor.
Have you discussed with him any of your ideas as it relates to this case?
Yes.
Are you satisfied with his services?
Yes, I am.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, OWI 10th or more, a class E felony, how do you wish to plead?
I wish to plead guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
My apologies, Your Honor. I might have missed it. So the joint recommendation, I'm just filling in my apologies. So joint recommendation is 4 years initial confinement, no agreement on extended supervision, just the confinement.
I believe it was the statutory minimums.
Okay. Just wanted to clarify, Your Honor. Thank you, Judge. This is a case where dispatch received a call about an unconscious driver that was passed out behind the wheel of his vehicle. I believe the joint recommendation is appropriate in this sense, given the defendant first and foremost is taking responsibilities for his actions. While this is a serious level offense, I believe the sentence will provide Mr. Hess the opportunity to take advantage of whatever programming is available in the jail to help tackle that alcohol abuse problem that seems to be plaguing him. But it would also accomplish the goal of general and specific deterrence. First, by specifically deterring Mr. Hess as he has reached the highest level of felony OWIs in Wisconsin. From here on out, any subsequent conviction will carry a mandatory minimum of 4 years of initial confinement.
I'm going to stop you. He's reached that, but what is his actual number?
This is number 10, Your Honor.
This is actually number 10.
Yes.
All right. Now you may continue slower.
Thank you, Your Honor. But secondly, we also want to generally deter the public here. Driving under the influence will be taken seriously, and these offenses can carry a mandatory minimum sentence. The need to protect the public will also be accomplished here, since the defendant will be confined for initial confinement of a period of 4 years. The ultimate goal here should still also be to reduce the chance of recidivism. As such, I would ask the court to adopt the joint recommendation. Thank you.
Mr. Flisky, argument, please.
Thank you, Your Honor. When I first began representing Mr. Hess, he was very upfront about the need to take accountability and responsibility for this matter. The fact that he was willing to do that from the outset on such a serious case, Your Honor, tells me that he very much understands that this was a significant and severe error on his part. He has regretted it deeply. He's indicated that to me essentially every time that I've spoken with him. He deeply, deeply regrets the decision that he made. He's made no excuses for it. To me, I don't anticipate that in any statement he would give to the court, he would make excuses then either. He acknowledges that he did wrong here. This is something that never should have happened. It happened, but he is here today before the court to take responsibility and accountability for his actions. I would note very thankfully in the fact pattern here in the complaint, it seems that there wasn't any injuries nor any damage to any property. This was not the result of a crash, either with another vehicle or a rollover in a ditch. Mr. Hess was found unconscious in his vehicle, and later investigation indicated that he was operating it while intoxicated. I bring that up, Your Honor, because I think here the mandatory minimums are appropriate given the nature and circumstances of this case. I would note that the last conviction Mr. Hess had for this type of offense was back in 2016. He's indicated to me that for a significant period of time, he was sober. He was doing well in the community. It's my understanding that for the most part, actually, he's been a resident of Montana rather than Wisconsin these past several years. He advised that when he moved back to the area, he had some difficulties in adjusting to probation here. And what I mean by that, Your Honor, is that it sounds like he had several agents who were appointed and then were either transferred, quit, somehow removed.
We've had a lot of change.
There's been a lot of change, Your Honor. And I think that having that in the short period of time that Mr. Hess was in here, unfortunately, may have negatively contributed to the situation. I don't say that, Your Honor, to, again, excuse Mr. Hess's actions. They're not excusable, but simply to provide some context here that there were some supports that Mr. Hess could have received that unfortunately he wasn't able to get access to. I think overall that this is an appropriate agreement. I certainly think the public is protected. Mr. Hess was revoked on these. Of course.
You guys both like to speak a lot fast.
Of course, Your Honor. Mr. Hess was revoked on this matter. He is currently in custody at Dodge, so he will remain in custody in there for some time, to my understanding.
Is it 4 years?
I believe so, Your Honor. I think that the statutory minimums here, what's recommended is appropriate. Again, given the nature of the offense here, this is certainly a very serious matter, but looking to the lack of injuries, looking to the lack of damage, looking to Mr. Hess's willingness to be upfront before the court and say, I did wrong, I will take my punishment, I will move forward, and I will improve and not have this situation happen again. I think overall this would be an appropriate agreement. I will lastly add, Your Honor, that Mr. Hess has advised once he does get out of custody, he does intend to relocate back to Montana. That's where his family, friends, support group are located. It sounds like that he was doing quite well when he was in Montana. He advised that he was employed with the company True North Steel. I may be misremembering our most recent conversation regarding them, but it sounds like that may be an opportunity available to him should he return to Montana as he is planning. I think the programming available in the jail for Mr. Hess, in prison, excuse me, for Mr. Hess will be sufficient to address the ongoing substance use issues that he has been dealing with, and will hopefully provide a framework for him to avoid ever having this happen again and to never appear before this court or frankly any other court for this offense or any offense ever again. Overall, Your Honor, I think that the agreement here between the parties is appropriate. I would ask the court to follow it. Thank you.
Thank you. Mr. Hess, can you please, if you would like to provide a statement to me, this is your only opportunity to do so. You don't have to, but again, it's your only opportunity to let me know anything you want me to know.
The other thing I'd like to state is you said I'm very, very happy that no one was harmed. That the only person that is truly affected is myself. My intent was never to harm anyone, and I would like the courts to understand that. So that's basically all I'd like to add. Thank you.
Thank you. Mr. Hess, I believe that it's never anybody's intent to harm anyone when they operate a motor vehicle while under the influence and something happens. No one wants that to happen. Everybody, quite honestly, anyone who drives behind the wheel while intoxicated believes, I'm not drunk. I can handle it. I'm just going 6 blocks. I'm not going that far. And then something tragic happens. The court has to first look at the seriousness of this violation. This is an OWI 10th. This is very serious. This is so serious that 9 other times wasn't enough for you to understand and to learn not to get behind the wheel. 9 other times. Your blood alcohol content was 0.323. 0.323. It's 0.08 in Wisconsin to be above the legal limit. 0.323. That's extremely high. And you were passed out in front of the wheel. Not just sleeping. There's a difference. So this is extremely serious, and thank God, thank all of the spirits, and thank everything that we can that no one was injured or hurt, and that includes you, because we've had other situations in which it has been extremely different, and we've had to bury people or had people in wheelchairs for the rest of their lives. So this at least had that positive where nothing happened. I have to look at you and your criminal record. I do take into account, and I see that it has been 10 years, give or take, since your last OWI. However, the 9th still wasn't enough. It wasn't enough to say, all right, Mr. Hess, I'm not getting behind the wheel. I'm not going to put anyone at risk, and that includes me. I'll walk home, even if it's 10 miles, instead of getting behind the wheel and driving. And I have to look at the community and protecting the public interest here and the public in general. Because this is an OWI, it's serious in and of itself. But then when you tack on, this is the 10th, it makes it extremely more serious, because you can only tell someone so long and so many times, stop, stop, stop. Hopefully this was it. Hopefully this was the last time and you're not going to do it again. And hopefully no one ever becomes injured or killed while you're behind the wheel. With regards to this matter, you do have 4 years and some change to sit from your revocation. You were revoked off of extended supervision. I was toying with what to do if I follow the recommendation. But you have 4 years, and if the court follows the recommendation, that's 8, because the court, this is definitely a consecutive sentence. So I will follow the recommendation, 4 years of initial confinement consecutive to any and all sentences you are serving. You are not eligible for any earned release programming. No earned release programming. 5 years of extended supervision. You are not eligible for earned release programming while on extended supervision, because if you are revoked off of extended supervision and you still haven't learned your lesson, shame on you, shame on me. So with that, on extended supervision, absolutely no alcohol, no possession, no use. No bars, taverns, liquor stores, casinos, no establishments that have the primary purpose for the sale or service of alcohol, no beer tents, nothing that would serve alcohol. Regular alcohol testing, regular, that means you will have regular testing, and quite honestly, when you are released from extended supervision, the court will order that you must have a buddy bracelet or similar, meaning that you are wearing a bracelet that continuously tests your blood alcohol 24/7 for the first year while you are off of extended supervision, and then regular alcohol testing. Definitely absolute sobriety, AODA assessment and all follow through. Mental health assessment and follow through. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. With regard
That final OWI ruling was heavy. The court accepted the guilty plea for a 10th offense OWI, emphasized the danger to the public, pointed to the extremely high blood alcohol level, and imposed for years of initial confinement consecutive to the sentence he was already serving, plus 5 years of extended supervision, permanent license revocation, strict alcohol conditions, and major fines. This case shows how repeated offenses can turn a courtroom from routine procedure into a life-changing sentencing hearing. What's your opinion on this case? Do you think the judge's decision was fair, or too harsh considering the circumstances? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
to the OWI 10th, this is a doozy. The court is ordering $8,446 in fines and fees plus a $10 blood draw fee. Revoking your driver's license permanently. No chance of getting another driver's license. The court is ordering you provide your DNA. The prison will make sure that they have it. This is not something you can have it expunged because it is so serious. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, but the court will issue a warrant. You could sit an additional 6 months in jail. Mr. Vila, what is the court missing?
I don't think you're missing anything, Your Honor, not from my perspective.
Mr. Felisky.
Nothing further. Thank you.
All right, thank you. Then we are adjourned. We will go on the record in the matter 24 CF 119, State of Wisconsin versus Jeremiah Wagner. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Joel Felisky, Defense Counsel in person. Mr. Wagner appears by video conferencing with approval of the court. We're set today in this matter for a status conference. Mr. Felisky, please update the court.
Thank you, Your Honor. I've attempted to contact Mr. Wagner several times today. He wasn't able to get back to me. I understand that he had his St. Croix matter today. Mr. Wagner.
Yeah, so in St. Croix County, my lawyer got an offer from the state and then she just put in a counter offer and was waiting to hear back from them.
All right,
so that's kind of where we're
at. Court's taking judicial notice 24 CF 294, set for jury trial June 17th, final pre-trial June 8th at 10:30.
She said that she was expecting probably to hear something back today, so.
All right. St. Croix. All right, so what I'm going to do, there's nothing else set on the calendar, not a status, not a potential plea and sentencing. This is your case?
This is a D.A. Schmidt case, Your Honor.
All right. February 13th, can you come in? Can you do 9:15? Are you coming in? I don't know if I have you, Mr. Felisky. I have you, that's February 12th at 9:15. I have you.
Either date will work, Your
Let's
Honor.
just do February 12th at 9:15. You don't have to come another day if you don't want to or have to. So February 12th at 9:15, we'll have another status. You can appear by video as you've done so today, Mr. Wagner. Please be in contact with your St. Croix County attorney, and like today is Thursday, so early next week to see if she's heard back. If you already haven't heard from her, then immediately call Mr. Felisky. And if you don't connect with him, leave a message so that with a time he can call you so he knows he can try and get a hold of you, okay?
Sounds good.
All right, thank you.
Yep, thank you.
We're adjourned. Wesley Alwyn. Nope, I'm just waiting. You have Wesley Alwyn? Nope, I do not again. I think it says that you arranged it, but I don't have him. He wasn't in court the last time. We're going on the record in the matter 25 CF 170, State of Wisconsin versus Wesley Alwyn. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Felisky, Defense Counsel in person. Mr. Alwyn fails to appear again. Well, he might be popping in late. I have a small hearing room, so I'm going to bring it in and see who it is. Who is the small hearing room? I cannot hear or see you. Is this Mr. Alwyn?
Oh, yes. Yeah. Can you hear me now?
Yes. Mr. Alwyn appears by video conferencing in custody in St. Croix County Jail. We're set for an initial appearance. Mr. Felisky, did you go over the criminal complaint with Mr. Alwyn?
I did, Your Honor. I believe Mr. Alwyn understands the charges here. and the maximum possible penalties. Will waive formal reading to any misdemeanor counts, enter in pleas of not guilty. We would ask for a preliminary hearing within time limits.
All right, this is just a felony. What the court is going to do is, within time limits, then he's gonna have to stipulate to his, identity. 'Cause he's in St. Croix County. Otherwise, I'll just reissue the warrant and we'll wait until we get him. Because this Zoom appearance is for his convenience only, not this court, and I'm not placing that, responsibility on our jail. I can do February 5th at 11:15 or at 11, let's just do, if you can do the 1:45.
Unfortunately, I have a revocation at that time, Your Honor.
What about the 11:15?
The 11:15 should work, Your Honor.
That's fine. I guess I have another prelim that morning too. So February 5th at 11:15, February 5th at 11:15. Please, Mr. Felisky, make sure that they are running on time and that they will have him ready, okay?
Yes, Your Honor.
Thank you. We are adjourned. Can you hear me, Mr. Keen?
Yes, Your Honor.
We will go on the record in the matters 25 CF 164, 25 TR 953, State of Wisconsin versus Mark Quinn. The state appears through Assistant District Attorney Jose Vila in person. We have Glenn Keene, Defense Counsel, by video conferencing with approval of the court. We also have his attorney, Mr. Quinn, by video. Mr. Keene, his video is not on right now, but that's fine. I can hear him. We're set for a preliminary hearing, but I have received a very thorough and I appreciated preliminary waiver form from Mr. Keene. But I'm going to tell you, Mr. Keene, the next time it's going to need to be really signed by the defendant if they're going to be by video conferencing. Mr. Quinn, did your attorney go over all that's contained on that preliminary examination waiver form?
Yes, he did, Your Honor.
Do you understand it completely?
I do.
You understand that once you give up your right to a preliminary hearing, you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely, intelligently, and voluntarily?
I am.
We'll find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila.
Thank you, Your Honor. I'm going through and filing the information as we speak. It will mirror the criminal complaint.
It mirrors the criminal complaint. Proceed with an arraignment today or set for another date.
Today is fine, Your Honor, and understanding that it mirrors waive reading and Mr. Quinn would plead not guilty. We would ask for a status a few months out because Mr. Quinn is in inpatient treatment and have already had discussions with the state on possible resolution.
All right.
It'll take some time.
Okay, let's schedule you for March 2nd at 10. March 2nd at 10. You're coming back that day for other matters. So March 2nd at 10. Okay. It's a status. I'm fine if you want to appear by video conferencing. Again, Mr. Quinn, I'm okay with that. Okay.
Okay.
All right. Thank you. We are adjourned.
Thank you.
Oy vey, I keep going to put myself out and then